All right, our first typo is a millennial. This will be Anna. The fact that Karen's daughter's name is Anna and she's 22 is completely coincidental. That emoji looks nothing like her. So.
And that we gave it to the most crotchety KSB lawyer to deal with the millennial. So.
All right, so we've got Anna. She's a first-year teacher who wasn't thrilled about basically moving to Wyoming here in Nebraska to teach in your district. She got good grades and was charming during the interview. She had a pretty solid first 2 months, but really started to struggle in November. Anna is struggling to control her fourth grade class, and her lesson planning and weekly grades have slipped. You've been in the room regularly, and she gets really frustrated by you being there and by the kids. Things are getting worse, and you are getting complaints from other teachers that it's spilling over to their rooms. You're worried that more experienced teachers with kids in her room are getting upset. You have given Anna several ideas orally, and you've sent her some written materials on classroom control. You've thought about sending her to a training on classroom management, but haven't done so yet. Your superintendent and the board members are hearing grumblings, and a parent with a kid in the class stops you in the parking lot after the last football game. Just got to Anna's name on the evaluation list, and you keep to be sure that you complete all evaluations. Superintendent checks in with you and says, hey, you're in control of this, you're on top of it, right? Now what do? All right, we've got several evaluation requirements under state law, Rule 10, and under your board policy. Sometimes they're the same, sometimes they're not, and so you have to look in all three places. Rule 10, as you'll see, adds a few adjectives and adverbs sometimes that I think they're trying to steal second base, if not home plate, and so we'll take a look at those. We put the statute in here just so, hey, take a look at it, but we'll summarize this in a minute. But part of what I want you to take away from this is there's nothing in this statute that says you have to give anything in writing. But I would strongly encourage you to be crazy not to do all of this in writing. It says down in the third paragraph, you give a list of deficiencies, a list of suggestions for improvement. There was an old Nebraska Supreme Court case where the argument was, well, they didn't give it to me in writing, and a court found that the oral suggestions that were given were sufficient. I'm not so sure that would fly today because it was before they amended Rule 10, and it's an issue that hasn't been litigated yet, and I'd rather keep you guys out of it. I think we win it, but I'd rather keep you guys out of it if we could. So take a look at that when you get a chance. Rule 10, you have to have a written board policy for the evaluation of certificated employees. It has to be approved by the commissioner. That is an ongoing issue that we have, and it's one of the NSEA tactics that they use. We need to make sure that the evaluation instrument that you have on file with the department matches the one you're actually using.
Can I just jump in there?
Sure.
We have started, just as a matter of course, ordering that from the Department of Ed. If you have not personally put eyes on what your board has on file, you should call the department and ask. It is shocking to me, probably what, 30% of the time, 20% of the time?
Yeah.
The instrument that the school has used to evaluate the teacher is not the one that's on file. And the NSEA has figured this out, so they've started asking. The farthest I've ever gotten using the wrong instrument, we were taking depositions, and I ended up discovering that that we hadn't used the right form. But we don't take depositions in every case. And you do not want to be in a board meeting at midnight and have the NSEA whip out a different instrument that you didn't use. So that's one piece of homework for everybody to have, to double check and make sure you're using the instrument. Even if the one on file is crap, use it and then change it.
And I would check both your certificate, your teacher evaluations, and your superintendent evaluations. Yes. What we find is compliance goes like this. It goes up and down, up and down. It's because we present or the other firms present and they tell you, hey, check this. Everybody does. A new superintendent moves in and says, I don't like this instrument. They start using a different one, don't bother filing it. And so don't assume that whatever you're using is the one that's on file with NDE. These are the other Rule 10 requirements. You have to have written procedures, and you have to have specific district-defined evaluation criteria. Up in that right-hand corner, this is where they kind of steal second base a little bit. I'll talk about it in the other slide as well, but you have to specify all noted deficiencies. That's not in the statute. It doesn't say all. It says they'll give you a list. And so they put a little bit more of a burden on you there. The specific means for the correction of the noted deficiencies, again, specific means is not in the statute. It says a list. of suggestions for improvement, and then an adequate timeline for implementing those concrete suggestions for improvement. I think I know what concrete means. I'm not positive.
It's definitely not cement.
But yeah, it's definitely not from the statute either. And so they've slipped that in there too. And you can see they're trying to put the burden on you to be more specific and to provide more rather than less. So just keep in mind that the rules are going to require more than what the statute does. Rule 10, again, there's make sure your policy and evaluation instruments are the right ones. We talked about that. An example that kind of follows along with Anna's hypo, we had the Cox case back in 1997. It's one of the first cases I was involved with as a new attorney. It had just come out when I had started. We had a first-year band teacher at Cool Junction. She had not been formally evaluated in the first semester. But come the end of the first semester, students, they put in a policy, the administration put the policy in that says every class has to have an end of the semester test. And so they had apparently never had one in band, or it hadn't been much. She instituted one and the students revolted. They just couldn't believe that they were gonna have to take a test in band. And as a result of that, kids were dropping out, threatening to drop out, things like that. And so now the school and the administration get a little freaked out that people are trying to take off. So she has her formal evaluation in the first semester. They don't give it to her, or they did it on January 28th. That's when they actually observed her in the classroom. But really the guts of her evaluation document was based upon informal walkthroughs and other observations they had made during the first semester. And the only thing they told her is you need to improve your communication, especially with students. You need to use positive reinforcement when appropriate, and that went back to kids were revolting when they had to take this test. And so January 28th was in the second semester. She didn't get that first semester evaluation. Supreme Court said it's undisputed that she did not receive a list of deficiencies, a list of suggestions for improvement, and assistance in overcoming the deficiencies, or any follow-up evaluations and assistance when deficiencies. Essentially what happened is kids and parents revolt, administration reacts, and it was a little too late. They hadn't evaluated her. And you can see there in that this is from the Nebraska Supreme Court. They're not quoting Rule 10 there, they're quoting the statute. And it doesn't have that additional information in it. It has to be based on actual classroom observations for an entire instructional period. That first evaluation she received was based on bits and pieces of informal evaluation that they had made of her performance during the first semester. So the evaluation summary, you have to do an observation and evaluation once each semester. We think that, I mean, obviously the best practice is get that all done. Not only the in-classroom observation, but the written evaluation and the meeting with the teacher to review that evaluation. That should all be done within that first semester and in each semester. It has to be a full instructional period. Don't pop out and cover an emergency. If you do, you're gonna have to redo the full instructional period part. You need to have a list of deficiencies. Again, it says written. That's certainly the best practice. The statute doesn't say that, but NDE will tell you that that's what's expected. I can tell you to hearing that absolutely we expected it. If you didn't do it in writing, you'll get grilled. Doesn't mean we won't present evidence on what was orally told to that teacher, especially when it's in between formal evaluations or in between an improvement plan. You need to have concrete suggestions for improvement, again, in writing. Sometimes this is where I think that when we look at the remediation plans, when we look at evaluations, this is kind of soft, it's kind of flowery, it's not as specific, and I think that concrete part might catch us sometimes. So we have to be careful about that. Sufficient time to improve. This can be problematic. That was problematic in the Cox case. They basically wanted a time machine to go back in time and make her improve. They didn't give her any time to improve. They just decided that kids have revolted and we're done with you. And I understand when you've got a bad teacher in the classroom, I mean, the research shows the faster you get them out, the better the kids are going to be. But we still have to give them sufficient time, and we have to make the effort to help them improve.
So Steve, if you're a mean lawyer and you, or a mean administrator and you want to make it look like sufficient time, is there any like verbiage you can put into the document to make it shorter? Because I say things like any competent teacher would know that they need to have grades entered. I expect that improvement to happen immediately. So those are, I mean, if you're doing a hurry up timeline, that's my point. If you're doing a hurry up timeline, kind of own it. But then what I try to do is make it sound like, because my very first hearing that I ever did was a teacher that wrapped herself up in saran wrap and met her husband at the door. and then told her kids in the classroom about it, which both my principal and my superintendent were kind of excited until they realized who it was that was wrapped up in saran wrap. And then anyway, so we got around the sufficient time to improve by saying, you should have known, this needs to stop immediately because you should know right now that that's not okay. So,
But to me, that's part of the thinking in making sure that every piece of paper that you give, you can point to something in your policy, in Rule 10 in the statute that you're accomplishing with that.
yes.
Because they will question why you didn't do that at a hearing. So to Karen's point, that's not mean to say that is probably actually true if y'all had to answer honestly. It's never been appropriate to talk about wrapping yourself in saran wrap and meeting your spouse at the door. So the fact that we expect that immediately, we can point to Rule 10 and say, look, this is we complied with it.
Yeah.
We're trying to get around it. The opposite is true.
Yeah.
But if you ask nicely in the evaluate or in our evaluation documents, perhaps we'll reenact that scene in saran wrap. You can maybe vote on who that should be.
No.
Anyway, our Supreme Court, we've had cases from other states where, I'll give you a ridiculous example, a teacher commits murder. You don't have to put in the evaluation document, don't kill students. I mean, that's silly. And so other states have made very clear, there are some offenses that are so bad you don't have to give any remediation. And we don't have great guidance in our state as to what that means. So we're, we kind of fine tune that as we go along, but just understand there are some things that are so bad that you don't have to remediate. You have to give that follow-up evaluation and assistance. I think as a principal, as an administrator, that's probably the most difficult and certainly most time-consuming part of this process. It's frustrating, especially, let's face it, there are times where you see a teacher that is so bad that you think, I don't want to spend any time on this teacher. You have to. And I get that can be frustrating, especially if they're not quite up to the cancellation line and you're going to go the non-renewal route. It can be difficult and frustrating. These are the statutes. We just put these in here so you'll have a chance to read them. We're going to summarize those here. The non-renewal process, you got to give, again, notice on or before April 15th. I would say check your contracts. There are still some old contracts floating around out there. And when I say, I'm talking mid-70s, that give an earlier deadline than April 15th. Number one, to give those contracts, update them. But two, just check and make sure you don't have a different date in your employment contract or in your negotiated agreement. They have 7 days to make a request for a hearing. If they do that, we have 30 days to hold a hearing. But we have to give them notice of the basis for non-renewal, a list of the witnesses, and any exhibits we plan to use at the hearing 5 days before the hearing. The matter has to be confidential until the hearing or board action is scheduled. And that can be tough sometimes. Rumors start to float around in the smaller towns. But as long as they're not coming from us, the school, the administration, the school board, we're in good shape. There it is that you have to conduct that hearing before the board within 30 days of the hearing request. That can be extended if both sides agree. But otherwise it's 30 days. Statutorily, it does say this will be an informal hearing, but in reality, that's not how it works. In the good old days, it really was informal. The teacher would come to the hearing, maybe with a rep, maybe by themselves, and they would plead their case to the board. And that, I think, was what initially was intended. But the first time one of those got appealed, the court said, where's your record? Where's your recording of what happened? Where's the word-for-word document that tells me what occurred at your hearing? They said, well, there isn't one. And they said, oh, reversed. You've got to have a record. The burden to have that record is on the school district. And so that has really made it more formal. And each ruling that's come from the court really has made it more formal to the point that if you went to a non-renewal hearing or a cancellation hearing for that matter, you wouldn't be able to tell the difference in all likelihood. They have a chance to discuss and explain their position on continuing employment. It's a little more than that now. It's examination and cross-examination and redirect and recross-examination. It goes on and on. The board decision may be for any reason except an unconstitutional one. And that's one where I think I'm anxious to test is for any reason or no reason at all. They just aren't good enough. They aren't good enough to be a Duke. They're not good enough to be a Cardinal, that kind of thing. A majority of the quorum for a probationary teacher is sufficient. So if 4 people show up, you could have a vote of 3 to 1, and that would carry the day. As you'll see, that's a little different for the more formal people. The employee may resign, a probationary employee may resign by statute at any time before final determination by the board. And I think Karen and I at least have had this experience where you do the whole hearing, they go into deliberate, and the teacher and their representative get together and meet and decide we're getting fired. We knew this was coming. Now I really know it. And so they'll submit their resignation so they can say they quit instead of being fired.
And I had a board say, oh, hell no, you put us through this. We want to come fire you. And it was like, no, she's entitled to resign. And so then the board came out of closed session and the board president read a statement that said, they were so mad. We were going to fire her. We had to accept her resignation because the lawyer said we had to, but we really wanted to fire her.
All right, and the final decision must be made by May 15th. Again, that's by statute. It has to be a written decision. All right, so our options with Anna, what can we do? Obviously, the sooner you get legal counsel involved, the better. The earlier in the year, we can make sure that remediation process goes as smoothly as it can, and it'll be legally sufficient by the time we get to the end of the year, or we reach the point where cancellation is going to be necessary.
Well, there's a reason we're doing this presentation right now in November
Yes.
and not in February. And that's because you're most likely to avoid a hearing by starting to think about one now.
Here's how we process the case. Can she improve? Really, I look at first, did you help her? Did you actually help her remediate? What kind of things can we do to remediate that teacher? Is it more likely a cancellation case? How bad is it? In this case, there was talk of sending Anna to the class management course. And okay, we're going to talk about, are we actually going to do that? Is it even available during the middle of the year? Is it too late? If it is, what are we going to do? Are we going to observe her classroom, have her video? Are we going to have her read books? What are we going to do to make sure that we're doing our job and make sure that she can finish out the year? Will the board support you? This is an ongoing issue. We can have a legally airtight case. It doesn't matter if we've got political connections or a board that simply is not going to pull the trigger. And it seems like every case has some weird political issue. They go to church together, they're on some council together, their mother teaches at the district and has for 30 years. Dad owns the bank, dad's the biggest landowner in town. All of those kinds of issues come up.
Well, and part of the reason we put it in there, this so candidly, is at the point you're calling us, probably you've made a decision that that teacher's very likely not going to make it. And so we start processing the case from that perspective, but don't be offended when we ask you, is there a chance to, we're not educational experts, but we're asking that because that's exactly what the NSEA might ask you. When did you decide she needed to be fired? Right? If you're not prepared and thinking through that from the beginning, they're going to catch you in that on the stand. So that's why we just are straight up about, can she improve? What have you done? Okay, well, no. Okay, can she finish out the year, or is it too bad? And so that's how we think of it here.
Well, go ahead.
No.
I was just saying, this is where we look at the Cox case. You know, in Cox, in our case here, we gave her some oral suggestions. We gave her some written materials. We didn't give her an evaluation. We didn't give her formal suggestions for improvement. We haven't evaluated yet. So we need to make sure we jump through all those hoops to meet all the Cox issues so that we evaluate her in the first semester and give her all the help she needs and repeat that in the second semester.
This is the point, and we're going to talk about this at various times today, but talking about what your board needs us to prove, this is the time to talk about it now, not right before the hearing. So Joe works at the co-op and manages a bunch of lazy, shiftless people, so he's going to want us to be real hard-nosed. Sally goes to church with this lady, so she's going to want us to show mercy. The hospital administrator is going to be really offended by breach confidentiality. So understanding what your board members need us to show them in order for them to be comfortable supporting you, there's nothing wrong in that. That's just being a really good administrator and knowing what your board expects.
Well, I mean, if you're going to a jury trial, you spend days picking the right ones, right? Figuring out what makes people tick. You need to think of your board as your jury at that point, and that's how we're thinking of it. Because frankly, they are. In terms of getting the votes. And you know, the notion that you would call a lawyer before you even do the first semester evaluation of a first-year teacher, we wish that was less strange to think about to some of you, because we could, if you're already made this decision, when the superintendent sticks his or her head in and says, hey, we're going to address this, right? We're going to start asking you what that means. What is the end result here? And if you already know that, then they can help you make sure you tick the boxes for Cox and the rules.
Sometimes people go to hearing because they're going to go to hearing, but we are much more likely to have a case go to hearing if you call us after all the paperwork is done than if you call us before. And it's not that you're not competent, like you've got the educational stuff squared away, but having us be able to throw some of this stuff in early makes all the difference in the world.
The other options, cancellation. I mean, is she that bad? Is she so bad you can't remediate her? That would be tough in this particular case, I think. I think you're gonna have to jump through hoops and help her remediate. So that would be a tough sell. The counsel out conversation, this always makes me nervous. We have
Me too.
we have some veteran and some not so veteran administrators who think, oh, I'll just talk to her and by the time I'm done talking, she's not gonna wanna work here. She'll leave. It's a good conversation to have. It's just not, I don't want that to be plan A. I want that to be plan B.
Yes.
I want you to be prepared to move forward with a non-renewal or a cancellation if it's necessary. I don't want that to be, it doesn't matter if we screwed up the paperwork. It doesn't matter if we followed Cox. It doesn't matter any of those things. We're just, she'll leave. I'm good. And my fear is you get away with it once and it really empowers you to, this isn't that bad. All those things they said, it doesn't matter. So just be very careful. Yes, we're going to have that conversation, but that's plan B, not plan A. An improvement plan, are we going to do one? What are you going to put in the evaluation, as we'll talk about a little later. It doesn't have to be a separate document. It can be. It doesn't have to be. And the improvement, I guess maybe this is as good a place as any to talk about one of the NSCA tactics on these plans and evaluations. It is a hot button issue with NSCA that attorneys review these documents for you, make changes to them, or outright write them. They do not like that. They are attacking that before the hearing. They're attacking it in meetings with you. They're attacking it at the hearings. And so in a perfect world, you guys would write great improvement plans and wouldn't need any input from us. You can honestly say, I wrote that. And so just be aware that the NSCA is coming after schools and administrators for having other people write their plans or even tweak their plans and evaluations. And evaluate no matter what, don't pull punches. And we see this a lot with what we call the cliff. They'll have great evaluations for 2.5 years. Then you start swinging in that last half semester or last half of the year. You got to be direct. I mean, you don't have to be mean, but you do have to be direct. If you see deficiencies, you have to note those. You have to tell them, and you have to get those remediated.
I just want to jump in here. I always think of the verse in Ephesians. If you want to be kind to people, and you're like thinking, what would Jesus do? Ephesians chapter 4 says, speak the truth in love. Lying to people, telling them they're good when they're not, that is not loving. That is not a kindness. In fact, it feels like a betrayal to the teacher if you have not been honest with him or her about their deficiencies. So I just throw that in there. They hear me say it here all the time. You speak the truth in love.
And I was born in Detroit, and I say burn their house.
Real quickly, for those of you that are having issues, I just checked. Let us know if those continue. It seems like it is kind of a mixed bag. So anyway, sorry.
All right, give that written list of deficiencies, concrete suggestions for improvement. Again, your evaluation could be the improvement plan. It does not have to be a separate document. And consider the timeline for issuing that notice of renewal. If you issue it early in the year, you've got a lame duck teacher for the rest of the year. That's not ideal. On the other hand, if you've already made up your mind, we really want to continue for several more months limping through. So giving, that's kind of an art at times as to when you're going to give that notice of non-renewal.
I just have to tell you, I love this. Well, see, I love this back channel because I have some of you texting me. Someone just thought maybe lightning would strike if I was quoting Bible verses. So that's